We are live. I'm just waiting for our architect.
All righty, we'll get started then. Thank you to everybody who's joining us here in person and online. The first order of business is going to be to approve the minutes from last month. It was July 25th. And it's been distributed. Everybody's gotten a chance to take a look at them. I will make a motion to approve. Do I have a second?
A second.
Second. All right, Charlie, we'll start with you.
Yes.
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 All righty. So the minutes from last month are approved. And we, as it happens, we had two motions on two continuances really on the agenda for tonight, but one of them has been moved to September. So we only have the one, which is 7 Bertha Place. And I don't know if is the architect here. Yes, he is. Great. The first thing, well, why don't we get him on and then I'll give my disclaimer.
Hello, can you hear me all right?
We can see you, we can hear you. Yes.
Okay, great. Great. I appreciate the board convening this meeting. I saw we were the only ones on here. We really appreciate it. It's a tough time of year to get everybody in a room. So we appreciate you coming here tonight.
Well, thank you. And just to that point, I will say there are only 4 of us here tonight. We're missing 2 of our members who are not available. One of our members is, John Dimling. He is
A neighbor.
he is a neighbor, so he's not going to vote, which means there are 3 of us, and all 3 of us have to say yes. There's no 2-to-1 decisions. You need 3 people.
Understood.
I just want to give you that disclaimer up front before we tonight. Great.
Great, we understand that. Yeah, thanks for clarifying. So yeah, I'm Brandon Stewart, representing Michael Lewis Architects and Danae and Jim Pieri, the owners at 7 Bertha Place. And Michael Lewis is also here with us. And so we'll try to keep our presentation brief. We heard the board's concerns from the June meeting, and we endeavored to respond to each item. And I'll just walk you through the changes very quickly that you've all seen. Can you see this plan now with the purple in the middle?
We can. Yep.
Okay. So we understand the troubles that we had on with our calculations with regards to coverage. So in the first place, I'd just like to point out the different things we've done to try to reduce the variance there. We've reduced the length of the sunroom by 1 foot, which we feel is the most we can do to really have it still be a functional room in there for what the owners need it for. And we were able to remove an entire storage space on the side of the garage on this side. And then lastly, we've decided to also propose converting this front walk to a gravel walk to reduce some site coverage there. So we've tried both with actual hard building coverage and with general site coverage to bring our numbers down. And so whereas before the existing coverage on the site is 155%, we were previously proposing an increase to that to 161% of allowable coverage. And now with the reductions, the percentage is coming in at 143%. So a net decrease in coverage on the site and a decrease of about 12% of coverage. That includes, so that's 300 square feet to convert it into square feet, 300 square feet of documented coverage that is a net decrease, and that's not counting the portions of undocumented coverage that we're also removing. So in total, from an environmental point of view, we're removing about 540 square feet across the whole site. And so let's see. Then the other variance, as you know, is for this side setback intrusion. And again, here's the size of the kitchen addition. And while it doesn't increase the nonconformance in that it doesn't make the 7.4 foot setback to the corner of the garage any less, a portion of it does sit in the required side yard. So that's the variance required there. And lastly, the documentation of the existing driveway turnaround, which we spoke about last time at length, and that's here. Just to run you briefly through these diagrams again, here you can see again that portion of driveway turnaround in context with the neighboring properties. And also we've shared again with you the aerial views of our property and the others along the Croton buffer that are subject to the same regulation, in hopes to point out some of the vegetation that we have that's robust, and also to show relative to some of the other intrusions that we feel like this would be difficult for a future applicant on a project along here to point at our particular property as a precedent setter, since it's relative to the other properties, it's a very small amount of paving. And we heard you, we were listening and tried to illustrate the best we could for this particular legalization, that it doesn't seem inconsistent with the character of the surrounding neighborhood. It seems like the minimal feasible legalization variance. We've also removed the basketball hoop that we understood was a problem, and we see that it's not a unique variance. It doesn't seem it wouldn't seem like a precedent setter, and again it's not self-created. Again, looking at this, the previous survey from 1988, where the driveway was much larger than it is. The owners moved in and inherited this amount of paving in the buffer. And lastly, I assume the letters from the neighbors have been circulated to the board members?
Yes.
Okay.
Right, Rosie, got them from, yeah. Yes, we all got them. Thank you.
Great. So I've got those here, and I'll turn the time to Danae to explain a little bit about those. And Danae, I can put this up on the screen if you'd like.
Sure. Excuse me. And not you need to.
I think you just because for the camera
Oh, for the
view.
camera,
Right,
okay.
yeah.
Okay, so hi, I'm Danae Pieri. I'm one of the owners at 7 Bertha Place with my husband. We have 2 children, 2 daughters. So I just wanted to maybe provide a little bit of color. So I know I wasn't able to speak at the last meeting. So I wanted to come in person for this one. But I know that there was concern mostly because of the basketball hoop in the initial beginning of this, and that has been removed, before getting here. And so when there was a request to remove that additional functional space, I did want to make sure that the neighbors in the neighborhood would understand, because it would just impact us. It would impact specifically the houses across the street from us, the 2 houses across the street, and then Miss Myers, who's on 5 Bertha, who's property is adjacent to that driveway. So the way the driveway, and you can see here, it's actually, when you come out of it, that sharp, almost 90-degree turn, you can't see around the corner the way, I know a lot of people back out of their driveway, so it's not crazy to say back out of your driveway, but the way that the angle of it is, you can't actually see around the corner. And so it does create blind spots. And then when you come down and you're getting towards Bertha Place, there's these beautiful 100-year-old trees. There's 4 of them right by our mailbox there on the right side of the driveway. And so there is additional blind spots created going out there. And if you've ever, I know, Mr. Dimley, you're recused, but it's a busy neighborhood full of kids. Miss Myers gets, grandchildren all around. And then across the street, the Libbies and Angela Mon, has kids as well. So I know they've expressed that.
That's what all that noise is.
Yes, there's always kids on the street, but they've all come over, looked at the backyard themselves, just so that they could see for themselves the driveway and what that would be like. So I'm happy to answer any questions. Again, I think, Brandon hopefully, summarized a lot of the, when you look at all that's in the aqueduct buffer, this is a very small sliver of a very functional piece of our driveway. If it were removed, I think people could still turn around. They would just turn around the grass in my yard, and it would completely tear up the beautiful yard that we have. So I don't know if there's any questions. I'm happy to answer any questions.
Anybody, do you have any questions?
So what you're saying is you're unwilling to take out that macadam, that 108 square feet.
I'm asking if we can get approval for it so that we can keep it, because it would from our perspective, we love living on the aqueduct buffer. It's the main reason why we bought that house. So we want to preserve the look and the feel of that. We walk behind there with our dogs and our kids ride their bikes back there all the time. What we are asking is to be able to still keep the functionality of the driveway, which, I spoke with the Classens who used to live there before we did for over 20 years. And she kind of chuckled. Susan did and giggled. It was like, yeah, if you don't have that piece, you're not going to be able to turn. She goes, we had people running, that tried to back out because it's a really hard driveway to back out and running over the yard. So I'm just asking to be able to keep the functionality to turn the car around. And then I think to just echo what the neighbors have said of just not increasing the risk of cars that don't have backup cameras, that don't have sensors. It's extremely, like, I would have to remove some of those trees or think about what to do with the plantings because there's a lot of blind spots and I wouldn't feel comfortable. I know, myself just backing out of there. It's not easy, and I'm cautious and I have cameras and I don't do it. It doesn't feel safe.
So what if you took the macadam out and put in gravel?
Gravel in the buffer, yeah, okay.
Right? Gravel doesn't count, right?
Oh, well, one of the things that maybe this didn't come up as much in our meeting with this board, but in the planning board, in the discussion around the relocation of the basketball hoop, that was kind of one of the things that we tried to hold on to, was still having that basketball hoop, but just outside of the buffer so that it complies with village zoning. And that was kind of a part of it, was to be able to, that would not allow us to have that there either. And so I don't know, one of the things we were just looking at is we understand very well as architects the danger of setting precedent, and we understand these 5 criteria for granting a variance or a legalization, that you have to be able to prove that there's no detriment to the neighborhood, to prove that it's not a self-created problem, to prove that it's the minimal ask to achieve what the owner needs. And we feel like we've demonstrated that those 5 are have been satisfied. If not, we're open to hearing which of them we think we need to show more. But that it seemed like in this particular case, given the scale of it and given that those criteria seems to be met, and also these concerns from the neighbors, we felt like it satisfies, but open to hearing where you think it needs to be shown further.
Well, I got the chance to go out there today. And first of all, I'll give you what I'm thinking, and then everybody else can definitely chime in and let you know where they are or ask whatever questions they want to ask. I appreciate the reduction in the coverage. I think you did from my point of view, a good job on that. I'm not terribly worried about the side yard setback in terms of your plans. It doesn't intrude any more really than the rest of the house. I did drive up your driveway today. Nobody was there, but I did want to get my own look at it. And I really don't know how you'd get out of there without the turnaround. That's a pretty difficult driveway to back out of. And obviously it's not just you, but it's, Amazon drivers and
my kids too.
and teenagers when that time comes. And I think you need a turnaround there to safely get out of that driveway. I do. Does it have to be paved? Could it be gravel? It could, but I do appreciate you moving the basketball hoop. And it's not, we're very protective of that buffer because the aqueduct is something that we've always really treasured and tried not to intrude too much into that buffer. So it has to be a pretty unique circumstance, but 108 square feet for something that you really do need, in my opinion, I would be willing to do this, but I am one vote. So that's it. I want to hear If
Thank you, by the
anybody
way, for
else-
driving.
Oh, thank you, yeah.
Because it is,
I wouldn't want to back out of there. I wouldn't. And I'm a pretty good backer upper, but that it.
Were you in your big car?
Yeah, I was in my big car and it,
Not many.
not the mini, and it's
Yeah,
it's a tough curve.
yeah, I had stopped by on Saturday, there was nobody home then either, and I did not drive up the driveway.
You
but
could
I
have.
no, I know, I walked up and took a look, yeah. Yeah, I mean, I think it's tricky, I mean, I do think, which doesn't resolve this issue, I do think the standards we apply for intrusions into the aqueduct are not the more
Yes,
general
I
standards
agree
for
with that,
variances,
yes.
that
Yeah.
which does not, it's not in any way dispositive, but it's not just the same considerations. However, I mean, first of all, this is a fairly compelling diagram showing that pretty much everyone except for 5 Bertha Place has intrusions more significant than yours into the buffer.
And the other thing, I know that I think even Miss Myers had mentioned that in her letter, just the amount of coverings, and we're through what we've proposed, we're going to add additional plantings so that it's even more covered.
It's pretty well screened from the aqueduct, I mean.
Yeah.
Some of the other driveways, you can see them, but like at least this piece you can't see when you're going back, maybe in the dead of winter when it's like nothing
Yeah.
Yeah.
there.
And I think ideas of converting it to something else, to something that is more pervious. We would have explored those types of solutions if we felt that it would have provided some benefit to the village. But given its invisibility from the buffer, its lower elevation from the trail, also the fact we haven't talked about this much, but the trail itself actually kind of bows away from our property at that juncture. So it seems like that would have been something we would have entertained if we felt like it would have helped some portion of the visibility of it, or other village residents experience of the trail, but it didn't seem to make any difference there.
So, like Sarah, I appreciate, the modifications that you've made for the other variances. However, I actually feel very strongly about the fact that nothing should be in the aqueduct buffer. And if I had the chance to remove those other structures, I would vote against them. Right? But those are buildings, right? They're not macadam. You could take the macadam out. There's an easy solution, put gravel in, you'd still be able to turn around.
And can you help me understand the difference between gravel, just so I understand like the legal?
I don't make the zoning law, right? But the gravel doesn't count against coverage.
Right, but just again, to play the devil's advocate here, we're not talking about coverage. I mean, well, we are talking
We were
about coverage,
talking about intrusion into the
right,
aqueduct.
which again, it's
Still an intrusion.
an intrusion. An intrusion is an intrusion, whether it's gravel or whether it's,
Well, I think an
pavement.
intrusion has to be structural.
then a driveway wouldn't count, would it? The basketball hoop would
Right,
count.
that's true.
The driveway isn't
But- no, no,
specified
but
in
the basketball hoop was not an issue. Right? The issue is the 108 square feet. The basketball hoop was not the intrusion.
No, that was just something that we felt was unnecessary in the
Right.
buffer from a personal point of view, but Rosie's right. I mean,
If driveways don't count for coverage,
right, then it wouldn't count, but
I
it
mean,
does
obviously-
because it's the Broadway
Yeah.
buffer. I mean, sorry.
it's
the aqueduct
just
buffer.
this weird thing where different provisions intersect in a weird way. And sort of how do you reconcile them?
Okay, it could be dirt. You'd still be able to turn around,
Very true.
right? So there's nothing about removing the macadam, in my opinion, that changes the ability to turn around.
Right. Well, I mean, you're right. It's a vehicle can still traverse it. It's harder to keep plowed in the winter and things in different times of year. It might not be as easy as the asphalt. And again, I don't know. I go back to some of what came up pretty heavily in during the planning board process was how much use Danae's daughters get out of using the driveway to play basketball almost on a daily basis, and that we tried in our deliberations with them and with you a little bit last time to try to make concessions where we can, but that's one thing Danae's talked to us a lot about, is just to please try to maintain that ability for her girls to play basketball back there. So that's one thing, that's the major thing that comes to my mind about converting that all to something that you couldn't bounce a basketball on. But yeah.
I guess maybe, I've been trying to figure this out myself. Like I know some of the wording on trying to specify what is children's play equipment, because that is within the buffer and what's allowed and not allowed as part of that definition. And it does specifically say no basketball hoop on a driveway.
Right.
So we have removed the basketball hoop, but it does talk about other things as sport, enabling sports, sports courts, or it's like a sports complex or a skateboard ramp you can have, or different things. So I guess that was one of my things, is the driveway isn't specified there, but some of those things are allowed in the aqueduct buffer. And as a resident, just trying to understand is it like, what does that mean when it talks about like the sports
Right.
kind of complex? I mean, one could say that if I move my basketball hoop, it's part of the sports,
Right.
which is kind of a vague statement in those wordings, which says it's allowed within the buffer,
And-
which is kind of.
Oh, another thing we noticed in there, there's 3 buffers, right? There's the Cyrus Road, the Broadway buffer, and the Croton Aqueduct buffer. In both of the other two, the wordings for the other 2 buffers, it specifically talks about paving being prohibited. And the Croton Aqueduct buffer, however, it does not specifically call out paving. It just says intrusions, which we understand paving can be construed to be an intrusion, and we understand that by the board's opinion, it is an intrusion. And in just appealing to a strict reading of the code, it doesn't specifically prohibit paving. It just talks about no intrusions at all without a judgment by the zoning board of appeals. So that's one thing we noticed.
Yeah, I mean, I think this is an intrusion. It's an intrusion that I have come to peace with, but I'm not sure you have 3 votes here. So your options are this: we could put this off till September, where you would have a better chance of having at least one more vote, and then you'd have, another chance at getting, I mean, I can never guarantee who's going to be here and who's not, but August is a tough month to have a meeting. Or you could make a concession that we would be willing, we could do it tonight, that you take that out and put in gravel, and then I think you'd have a better chance of getting 3 votes.
Right,
Those, I would think, are kind of what you're looking at.
right.
Okay.
Sound fair?
Yeah.
Yeah.
And is it possible to move forward with the other pieces and
No.
separate this out?
Unfortunately, we have to take it all as
Because of the way the
piece
notice works. and
because of
everything.
the way it was noticed to the public. Yeah.
I mean, I'm still, I guess, trying to understand specifically, like if there's other things that we can do besides removing the pavement. It's also kind of like it's there, it's been there for
A long
many,
time.
many
Yeah,
years.
Yeah.
It's a functional piece, in relative to any of the other driveways that are there. It's extremely small. And so I don't know what that means when I know Tin Hancock just put their pool in and they've been here, and theirs is also a functional turnaround. Like their Tin Hancocks is a functional turnaround. So I know they just came forward last year to get their pool approved and didn't have to remove that
Right.
piece, which also has basketball hoop on it. But so again, it's just like if you walk back there, you can't
Yeah.
see it, and it's not an intrusion.
Yeah.
So I guess I'm not comfortable yet.
Right.
I'll I guess wait another month. And maybe I can even, I don't know. I know that the wording is not as clear. So is there somebody that we can work with from like the legal department to truly kind of get into the legal pieces of the wording? Because it's extremely vague when I've gone through it. Like I could put a skateboard ramp there instead of that, and it would be allowed, or maybe we call it a sports complex because that is allowed, which if I put my basketball hoop on my driveway, I mean, on my garage, then that would be allowed. So I want to make sure I understand the
Yeah,
legal
no,
wording.
no,
of
I
this
understand.
and
Listen, it's your home, so it's
Yeah.
important to you.
It's worth a month
Um,
for me personally to wait
Okay.
to,
I mean, the village attorney is who we have.
That's
consulted
who
with.
we consult. I'm
Right.
not sure how it works with citizens. I don't think it does, right? I don't think there's any,
Yeah.
yeah,
She can't represent both sides.
right, exactly. And that would sort of do it for our legal department. You know, we have.
well, no, I mean,
our
I would
attorney.
have somebody from
Right, right, right,
my
yeah.
lawyer just looking in meetings, because I think this gets down to some of the technicalities in the wording, and when I've read it, I don't interpret it to say that
Right.
pavement
right.
specifically as part of a driveway is not
And you know,
allowed.
yeah, these all
But-
laws,
but
right, are
Clearly, the planning department does because they referred it to us for the variance.
No, no, it does need a variance, yes.
yes, right.
Okay.
right,
But
right.
it says you can get a variance if you have sufficient plantings, and if you're not one of the children's apparatus specifications that came
Right.
out, which we did, we removed the
Right.
basketball hoop.
Right.
Which they did require us to do, and I understand that's black and white,
Right.
it's very specific
Right,
within
right,
the
right, right, right.
requirements.
That's.
But
really
the
laid
driveway
out.
is not specific.
Yeah, I mean, I think. From our point of view, I would say the driveway is the driveway and it's an intrusion. But I mean, I understand it is, like I said, if this is important to you, I would say take a month and take a step back and think about it. And consult whoever
Sure.
makes you comfortable consulting and come on back and we'll be here in September.
Okay.
Um,
And just so that I can understand, just from, so you, as a board, you traffic in these 5 criteria for granting a variance. So the converting of it from paved to something unpaved, is that, in your mind, is that helping with the precedent one that makes it more difficult for people to point to us as a precedent, or is it about the experience of users of the trail, or?
Right. I guess what I would say is the 5 criteria that we look at are for the general laws that have been set out on, let's say, coverage or, side yard setbacks or whatever, all the various things we do. Right. FAR. Those are what we would use the 5 criteria for.
Okay.
The aqueduct buffer, the Broadway buffer, and I think you said the Cyrus Field, right? That's the 3rd buffer, which we know.
Never-
Never comes
never
up
seen.
before us, but the aqueduct buffer and the Broadway buffer come all the time.
Mhm.
Because they are treated very differently in the code. We also treat them differently and have a higher standard with
Okay.
those. And that's how we have interpreted it over
Okay.
time.
And
But I would definitely say that coming back in September, not only might you have more people on the board and therefore, again, I can't guarantee anything. I never know who's going to be here and who's not.
Yeah.
But I also think it might give you some time to get some comfort with the law and talk to some people and about that.
Can you share the village, you said the lawyers, or I don't know if Michael and them have
It's on the village website.
Yeah, it's on the village website.
Okay.
Yeah,
Yeah.
And
absolutely.
is there a place, so you say that your standard is higher for the buffers, is there a place in the code that we can look, because I just thinking about putting this forth as a reapplication, I want to
Yeah.
make sure I know what is the thing that we're satisfying by converting it? Because I mean, at the buffer, I have the paragraph open here. I mean, is there another part of the zoning board of appeals powers or something that talks about
The fact that
yeah, higher
that it's
standard
treated
for us to match?
separately, it's been pointed out as a unique part that needs protecting, I think makes it sort of inherently, there's nothing that says what you can do on Maple Street in Irvington, but there's something that says what you can do on the Croton Avenue buffer, aqueduct buffer and the Broadway buffer, because those are considered unique features of the village that we want to protect uniquely.
Right.
So my only point being, yes, I hear you. And look, I think you got from me that I would maybe have a little more comfort with this than everybody on the board, but it is something that we do treat very specially and
Right.
that we act to sort of a unique level.
Okay. Yeah.
Can I just ask, is there, I'm just looking at these diagrams, is there a way of reconfiguring, basically taking that little bump out and maybe extending the driveway a little bit to the, what would that be, the south?
Yeah, it would
Um,
be.
So
Right,
squaring that off, but smushing it, kind of for lack
It
of.
doesn't allow you to get the car back
Yeah,
and go forward.
Yeah.
That's the problem.
that's the
do
problem
the
is that you
3-point,
need,
yeah.
yeah,
It's,
you need a
it's,
3.
yeah, you could take it all the way back and it still wouldn't solve.
yeah.
And that's why it's there. I mean, that's why it's been there and even though I guess it was bigger at one point.
Right, it's smaller now
Right.
because it is kept from a functionality perspective.
Right.
Um,
Yeah, well, let's all have a think on it. Sarah Palermo, just from a logistics point of view.
and I guess maybe just one more
sure.
question. So just to kind of round out, so I know we were trying to get a little bit more information on like the requirements that we
Yes.
can come back to
Yeah.
specify.
Yeah, please.
Also, I guess just from a precedence perspective,
Mhm.
I mean, I think I'll probably get questions from, the Libby's, Anamans and Myers. I think in their perspective as living on the aqueduct and living in this area, they did express specifically their concerns for the safety.
Right,
And so I understand that your point is make it gravel and then,
right.
but
Dirt.
well, then you're like turning around in my yard.
And also dirt, you wouldn't really be able to plow.
I-
the same
I,
way. It would
like-
have to be some sort of surface to get it clear in the winter.
I mean,
Right.
then you wouldn't need anything because you would just put the grass there and you would just drive on the
Right,
yard.
right.
And I mean, I lived on the aqueduct for 30 years. I see cars driving on the aqueduct. I don't think they should be.
No, I don't,
Yeah.
but I'm saying I don't want them driving on my yard. Our yard is beautiful and I would never want my yard to
But
be
that
torn
part
up.
of the yard is currently macadam.
Right. But I'm saying if it were dirt, I would have a big dirt hole.
Right. That might not be practical as something that you drive on in all weather, right? Right, yeah. Agreed, at least. I agree. Is there any other questions you have? So then let me
No.
just find out from a logistics point of view, this is their second time. So if they're coming back for a third time, I don't think they have to renotice for the third time, right? Okay, so you don't have to notify the neighbors. You can if you'd like to, but you don't need to send registered mail telling them that you're before us because the third time you're still good.
Okay.
If we go into October, you might notice.
May I ask, we see that there's a September 5th ARB application deadline on the horizon. Would that be something that the board would allow us to apply for and proceed on that front pending the granting of this variance?
I think you should go, right? Why don't you call Ed Marin tomorrow and ask him? I think my opinion is it's okay, but you should check with Ed.
Because that would be a really a huge benefit to Danae and Jim if they could continue on
I
that
don't have
parallel
any
track,
problem with that.
of course, with
Yeah,
the variance
Right, 'cause
pending.
Not holding you up, essentially. I have no problem with that, but that's really Ed's purview and Ed
Okay.
should let you know whether or not. Is that right, Sarah?
Yeah, because typically they have to have all their
Approvals before they go to ARB,
Okay.
but call Ed, see what
Yeah,
he
we can
says.
talk to Ed. We'll talk to Ed.
Okay, good. Yeah, okay. So let's do it. We'll come back in September and we will see you then and we'll all have a thought about it.
Okay.
Great. Thank you very much.
Thank
Thanks
you.
for coming in.
Thanks for coming in August.
Thank you.
Hey, goodbye.
That is all we have on for tonight. Great.
Okay.
Meeting adjourned. Thank you.